In today's digitally connected world, defining obscenity is not as simple as it once was. The internet and social media have created new challenges in balancing artistic freedom and public morality. Recent controversies, such as Ranveer Al-Habadia's case, have reignited debates about what qualifies as obscene content. India, being the second largest internet market, faces a growing need for stricter content regulation. But how do we define obscenity in a way that protects social values while preserving freedom of speech? What does Indian law say about obscenity? Are the laws clear, or do they leave room for misinterpretation and misuse? Understanding these questions requires us to first explore India's legal framework on obscenity. The Indian Constitution guarantees freedom of speech under Article 19, Clause 1, Subclause A. However, this right is not absolute. Article 19, Clause 2 allows the government to impose reasonable restrictions to uphold decency and morality. India has several laws regulating obscenity. One of the most important is the Bharatiya Nyaya Sanhita or BNS 2023, which defines obscenity and sets legal consequences for violating it. Section 294 makes obscene acts in public a punishable offense. It defines obscenity as content that is lascivious or appeals to prurient interest. Additionally, it includes material that has the potential to deprave and corrupt viewers. However, the interpretation of these terms remains subjective, leading to varying enforcement. With the rise of digital platforms, online obscenity has become a major concern. The Information Technology or IT Act of 2000 was introduced to address these issues. Section 67 bans publishing or transmitting obscene material online. Section 67A focuses on sexually explicit content, while Section 67B deals with child pornography, imposing strict penalties. Beyond the digital space, laws like the Cable Television Networks Regulation Act of 1995 prohibit broadcasting obscene content. The Cinematograph Act of 1952 empowers the Central Board of Film Certification or CBFC to classify and regulate films. Additionally, the Indecent Representation of Women Prohibition Act of 1986 bans the misrepresentation of women in media. Despite these laws, enforcement remains inconsistent and legal interpretations often vary. To understand this better, we must look at key judicial rulings that have shaped India's obscenity laws. Obscenity is a subjective concept that has evolved through judicial interpretation. Courts have played a crucial role in determining what qualifies as obscene. One of the most important cases in Indian legal history was Ranjit D. Udeshi versus State of Maharashtra, 1965. The Supreme Court applied the Hicklin Test, which originated from an 1868 British case, and defined obscenity as any content that could corrupt impressionable minds or deprave vulnerable individuals. Using this test, the book Lady Chatterley's Lover was banned in India. However, as societal views changed, courts started moving away from the Hicklin Test. In Avik Sarkar versus State of West Bengal 2014, the Supreme Court introduced the Community Standards Test, which assesses obscenity based on contemporary moral values and the average person's perspective. In this case, a semi-nude photograph of a tennis player was ruled not obscene, as it carried a social message rather than promoting lustful thoughts. Similarly, in Bobby Art International versus Ompal Singh Hoon, 1996, the Supreme Court ruled that the film Bandit Queen should not be censored, as it depicted harsh societal realities. In M.F. Hussain versus Raj Kumar Pandey, 2008, the court ruled that nudity in art is not automatically obscene, citing India's historical artistic traditions. These rulings reflect a more nuanced approach, but challenges remain, especially in the digital age. Considering these legal shifts, we must now focus on how digital platforms complicate regulation. With the rapid growth of digital media, regulating obscenity has become increasingly complex. A recent case, College Romance 2024, highlighted this issue when the Supreme Court examined vulgar language in a YouTube web series. The court ruled that foul language alone does not make content obscene, as the intent behind the content must be considered. However, global platforms like YouTube and Netflix follow US regulations, which are more lenient than Indian laws. This creates conflicts in enforcement and makes it difficult to hold creators accountable. Given these challenges, it is important to explore solutions to better regulate obscenity in society. Let's discuss how to effectively address obscenity. A clear strategy is needed to ensure better regulation. First, law should include clearer definitions of terms like obscene or lascivious and prurient interest to prevent misinterpretation. Second, public awareness must increase. Campaigns should educate society on the impact of obscenity and promote ethical content creation. Third, stronger enforcement is needed, with balanced policies that protect freedom of expression while ensuring social responsibility. Finally, legal reforms must align with modern digital realities. Updating laws like the IT Act, BNS, and Data Protection Act can help regulate online content effectively. While laws are essential, achieving balance between free speech and social ethics is equally important. As we move toward concluding this discussion, let's consider what lies ahead. Obscenity remains a complex legal and social issue. Laws must protect public morality while ensuring freedom of artistic expression. A balanced approach is needed to adapt to evolving social norms. Courts and policymakers must continuously update laws to keep up with technological advancements. Thank you for being a part of this important discussion. If you found this episode insightful, stay tuned for our next discussion. Until then, let's continue questioning, learning, and understanding the world around us.